Welcome to part 2 of this year's comparative commercial arbitration course in summary form. Where we got up to last time around was that we were starting to talk about the history of arbitration, and that's where we're going now. In reality, everybody's arbitration history is a bit different. Our notions of strong sovereign states that we're familiar with nowadays is actually a relatively modern phenomenon. The UK probably got there earlier than many. In the 16th century, one it always assumes, although whether that's right or not, historians may disagree. But our concepts of international arbitration could go back way, way beyond there. It's often jokingly said, and perhaps not so jokingly said, that the Trojan War began as a result of an arbitration in which Paris of Troy was given the choice, or was awarded Helen, who was married, of course, already to Menelaus. But that's sort of in the realms of mythology rather than history. What you do have is almost certainly tribal communities. If you're in the desert, you don't really think of taking a 5-day camel ride in order to get back to your large metropolis, in order to solve a dispute you may have with a neighboring tribe or indeed within your own tribal group. You just get on with it. You'll appoint somebody to do something to sort the mess out. And when that happens, whether it's an arbitration technically or not probably doesn't much matter. The individuals concerned may be more mediators than arbitrators, but that doesn't make a great deal of difference one way or another. Disputes happen and they need to be resolved, and sovereign states with their municipal courts aren't always available for this purpose. People often say that arbitration goes back to the Code of Hammurabi. I wouldn't be able to tell you is the honest truth. What we do also know is that there are documented references to arbitration in medieval times, and they appear to be linked up to things that were known in Britain as fairs. These were gatherings. You still find them today, but they tend to be fun fairs rather than commercial occasions, in which local farmers gathered together to sell their wares. Now, in reality, as international trade took its first faltering steps, there would be participants from outside England coming along to buy wool or sell wool or other products or finished products. It's implausible that there weren't some international examples. And these fairs required some form of dispute resolution. If you like, the modern GAFTA and FOSFA trade associations are the descendants of this, and also of the medieval guilds. You had to be a member of the guild in order to trade in certain markets. Nowadays, compulsory membership doesn't really operate, but you do have these associations which stem from a much older history. Further into Europe, particularly in the Baltic, we have the Hanseatic League. If you ever go down to Cannon Street Station with a good guidebook, you can go down to the bottom by the river and see some small traces of what was originally the Hanseatic League's station or weighing station on the River Thames. But the Hanseatic League inevitably developed a form of arbitration to resolve disputes between those people trading and shipping goods along the Baltic. And that's another reason why Anglo-German maritime arbitration developed. But there are lots of different ways in which these things emerge. Ultimately, dispute resolution becomes a facility as much as the ability to weigh your goods is. But legal systems have always been awkward when it comes to arbitration. They continue to be at times, while professing their support for the phenomenon. What that ambiguity or ambivalence is about is an interesting question to which no one really knows the answer. Was it, as Peter Sayre suggested, and Lord Campbell in Scott and Avery put forward, and a lot of what Lord Campbell said in the long version of his judgment in Scott and Avery has to be taken with a pinch of salt. It's basically not accurate. But the feeling was that judges could have been hostile to arbitration because their fees depended on the number of cases they did. The problem with that argument is it runs straight into a lot of evidence which faces in the opposite direction. We find plenty of judges who were very positive about arbitration in some sense or another. As we will discover when we look at England, we know that Lord Mansfield in particular was in the habit of taking hold of parties and saying, you know, you really ought to refer your case to arbitration. And we see in the 18th century the development of the professional arbitrator for the first time. In fact, in England, we have one of the older arbitration acts, it isn't in force anymore, the 1698 Act, where parties could agree to have their dispute made, or their arbitration of their dispute made a rule of court, punishable for breach by prison and fines. Before the 1698 Act, however, we know that judges were saying to parties, look, you know, you've got this dispute, wouldn't it be better if you agreed to arbitrate it? In that respect, the 1698 Act, put forward or drafted by the philosopher John Locke, who at the time was working as a civil servant, really confirmed existing practice. If you read the preamble of the Act, you'll see that, rather than creating something new. Well, actually, the novelty it created was that the parties didn't have to be in front of the judge. They could simply file an affidavit, that's a sort of statement of evidence sworn, and they filed it with the judge or the court, and the court processed the application, turned it into a rule of court, and off everybody went. There was no need for a formal hearing. So it slightly simplified the process, but fundamentally it happened long before the 1698 Act. Let's look at England properly and start where you have to start, really, which is Vinyor's case. In that case, which was, by the way, very pro-arbitration, Chief Justice Cook makes it very clear how in favor he is of arbitration by enforcing the bond, which was basically a penalty payable in the event of a breach of the arbitration agreement. So the parties agreed that in the event of any breach of the arbitration agreement, a sum of money would be payable. He said, yes, that was payable. But in passing, he made the point, which probably represented existing practice and view anyway, that the arbitration clause was revocable by either party. If you think about an agency relationship, you appoint an estate agent to sell your house, you always have the right, unless there's a term in the contract, to get rid of the estate agent and go somewhere else. Revocability, however, has done considerable damage worldwide, particularly in the USA, where it's still arguably the law in the state of Alabama. There was a case in the 1980s, Allied Bruce and Terminix, in which the US Supreme Court had to point out that in a case governed by the Federal Arbitration Act of 1925, the state law provision of Alabama law, which reflects the revocability rule, was effectively ruled out in cases of interstate commerce. We've seen already the English judges encouraging parties to agree to have their disputes resolved by arbitration, and in so doing, turn those agreements into rules of court. The 1698 Act becomes relevant or important because of the statute of fines and penalties which preceded it, which made the enforcement of bonds slightly dependent on whether one could show that the bond reflected the real damage done to the parties. It couldn't be a purely penal event. There is, though, some evidence, I've seen cases of bonds being enforced well after the 1698 Act. So Vignol's case wasn't dead, and arbitration agreements could still be enforced in the sense that if they did have a bond provision, the bond provision remained enforceable even if the agreement wasn't. In the long 18th century, as it's sometimes called, we see a phenomenon of a mixed development of arbitration. We have rule of court arbitration, encouraged particularly by Lord Mansfield in the 1780s or around that period, being reasonably well enforced, and in general, judges being very reluctant to interfere with an arbitration entered into, or arbitration agreement entered into, on the basis of it being a rule of court. By contrast, the enforceability of arbitration agreements that were not rules of court was much less effective. First of all, you had the revocability doctrine, and then the bizarre case of Kill and Hollister. It's bizarre because the previous year, the very same court reached exactly the opposite conclusion. And you're really not supposed to do that in the English legal system. Kill and Hollister raised the question of whether or not an arbitration clause could be enforced. And it was said that because it ousted the court's jurisdiction, the court would not give way to an agreement to arbitrate, and the parties would continue to be subject to litigation. It is something of an urban myth that this somehow destroyed English arbitration law. We know it didn't. Arbitration was everywhere in the 18th century in English society, and I've already mentioned that there was the development of the professional arbitrator, a phenomenon not previously noticed. The reality was that arbitration was either conducted on the basis of the 1698 Act, or it happened within the trade associations and the various other bodies where failure to conform to the arbitration agreement couldn't be punished or dealt with in a court of law, but was dealt with by the various trade or social bodies of whom the individuals concerned were members. In some cases, arbitration decisions were a vital necessity anyway. Without somebody to sort out problems relating to title to land, nothing much was ever going to get done. And very occasionally, the English Parliament, or the British Parliament, but after 1707, would intervene and pass a legislation requiring the arbitration of particular disputes. So arbitration was very much alive and well in the 18th century, but common law arbitration agreements did not get a great deal of support from the English courts. That is, until the mid-19th century. There is the strange phenomenon of the Scott and Avery case coinciding with the Civil Law Procedure Act of 1854. Scott and Avery was a curious case, an insurance case, and it involved the clause or the rules of the Newcastle Insurance Society, I think it's called, or something like that. You have to read the article on your reading list that gives you the precise details. And the rules said that reference to arbitration of any disputes was a condition precedent to going to court. Now, in the House of Lords, which was at the time and was until recently the Supreme Court for the law of England and Wales, we had the rather odd phenomenon of the judges being summoned. These were judges who dealt with the lower instance case aspects of the case, and I think on one occasion, one of the judges actually changed his mind. But they all issued their opinions, followed by two judgments in the House of Lords, which were in favor of rejecting jurisdiction over the case. What happened was that the insured went straight to court, and the decision was, sorry, you can't come to court because you have not fulfilled your condition precedent, which is to go to arbitration first. That's the overall majority. Some judges said, but Kill and Hollister means that the arbitration provision is effectively unenforceable, so we'll ignore it. So yes, you can go to court. But the majority took the view that without going to arbitration first, the court simply didn't have jurisdiction because the conditions contained in the agreement for that jurisdiction had not been fulfilled. This creates a form of enforcement of an arbitration clause, if you like. And it's certainly true that the majority of the majority in Scott and Avery believed that the court would then be bound by the arbitration award to reach the same result. Not all the judges, I think, appreciated this particular point. Anyway, perhaps the point had become slightly academic, courtesy of the Civil Law Procedure Act, which for the first time gave the court a discretion, not an obligation, to stay court proceedings brought in breach of an arbitration agreement. That discretionary stay remained part of English domestic arbitration law right up to 1996. And only the various international agreements, notably the Geneva Protocol and New York Convention, made the English courts give up their discretionary right to stay proceedings in international cases. But the grandfather of modern English arbitration legislation, and indeed a law that was adopted very heavily throughout the Commonwealth, was the 1889 English Arbitration Act. In the 1980s, I encountered it looking at Nigerian arbitration law as Nigeria adopted the model law, the question being whether or not under the previous regime, the arbitration agreement was enforceable. And the answer was yes. And it was enforceable because of the Nigerian version of the 1889 Arbitration Act. The 89 Act is important for another reason, because it contains what are known as the statutory implied terms contained in a schedule. Essentially, the idea is that unless the parties have agreed otherwise, the following rules will apply. We find this in modern arbitration statutes all the time. Unless expressly otherwise agreed, X. And this is the legislature indicating how they think arbitration should proceed while allowing the parties to contract out of it. There was quite a lot of the 1889 English Act that couldn't be contracted out of, notably the case-stated procedure, which was to come and haunt English law in the 1970s and led to the English 1979 Arbitration Act, and subsequently to Section 69 of the Arbitration Act 1996. France, well, the great thing about France is nothing is less than colorful in French arbitration law. In 1789, was it 1790, the French government declared that arbitration was wonderful, could be used for just about everything, whether voluntary or compulsorily, and inevitably there was a backlash. And the clause compromissoire, the future dispute clause contained in an existing contract, gets outlawed, unenforceable, void. Fortunately, other countries that adopted various versions of the Code Napoleon did not have the same provision, which made life a lot easier, because the clause compromissoire remained unenforceable even in commercial cases right until 1925 in the backwash of the Geneva Protocol, France needed to change its law to comply with the protocol. So it did so with a well-known provision of its Code Civil, which rendered commercial clause compromissoires enforceable. Not true even to this day, as far as I know, in act mixed, various people who are half and half commercial, and so not with consumers. How did the French courts cope with this? Well, they invented an idea of international arbitration. And they said, particularly in the 1950s and 60s, that the rules simply didn't apply to international cases, starting with the Galakis case in 1958, I believe, which dealt with the rule that said at the time that states couldn't agree to arbitrate. Well, the French Court of Cassation said, yes, that's true of domestic arbitration law, but not true in international cases, which rise beyond the legislation. And we see that with a whole range of other rules in the 1960s, including and 70s, including that rule about the unenforceability of the clause compromissoire in international cases. That goes out the window. This is Arthur Nussbaum, one of my great heroes, professor in Berlin, and he's very much part of a bigger story. I suppose before the 1890s, we should mention the fact that with German unification in 1871, you get a spate of civil codes, the ZPO, Civil Prozessordnung, of Germany and Austria, both date from the late 1870s, and they influenced countries all over the world. Japan notably bought the German version pretty much lock, stock and barrel. And we start to see a development of modern arbitration laws, really quite sophisticated ones, in countries like Germany, as they start to burst forward economically. I think by the 1890s, they've gone past Britain in terms of economic development. As these countries become more and more industrial, we see a phenomenon of various Congress resolutions. People would have conference, they'd resolve certain things about what arbitration law should look like. Germany in particular had enjoyed a lot of thought about private international law in the 19th century, and it combined with the civil procedure rule changes and codifications to generate a lot of intellectual firepower in the arbitration space, of which Professor Nussbaum was certainly a part in the early 20th century. After the First World War, the war to end all wars, so it was said, the League of Nations was created, and so was the International Chamber of Commerce, headquartered at the time, as it still is, in Paris. It became a significant player in the development of modern arbitration. And that leads us to the Geneva Protocol. And it is a document you do need to read. We're celebrating its 100th anniversary next year. And it's a much underrated document for a whole range of quite good reasons. But its main contribution was to declare the arbitration agreement, at least in commercial cases, to be enforceable if the case was governed by the protocol, which essentially meant parties from different countries agreeing to arbitrate. It's a small but modest step. It also, by the way, contains a provision in which the contracting states acknowledged arbitration awards to be enforceable. We tend to think of the protocol as being about agreements. It's not entirely, although the detail really isn't quite good enough. This does trigger a series of legislative changes, although if you consult US lawyers, they'll tell you that the Federal Arbitration Act is not connected to the protocol, which the USA never ratified. It actually is linked up to the New York Arbitration Act of 1920, which was challenged, by the way, in the US courts unsuccessfully, basis that it was unconstitutional, although strangely nobody ever argued that it infringed the constitutional right to trial by jury, which would have been a more interesting argument. We've mentioned the French Code Civil in 1925, allowing the enforceability of the clause compromissoire, future disputes clause, in commercial cases. And this all led on to the 1927 Geneva Convention on Enforcement. You really should read it, because if you don't understand the Geneva Convention, it gives you all kinds of problems, because mistakes are made by people interpreting the New York Convention in the light of the perceived failings of the Geneva Convention. There'll be a separate video covering the protocol and the convention, so I'm not going to deal with them in this video. Safe to say that these two conventions led to what was described by Professor Nussbaum as the arbitration movement. He produced the first set of yearbooks in German, the last of which was actually translated into English by the American Arbitration Association. And for those who don't speak German, is the one that's most easily available. And it does contain an essay entitled The Arbitration Movement, written by Nussbaum, which is well worth a read. It seems slightly naive looking back, but it reflects the enthusiasm that you get in waves for arbitration. The problem was, though, that fascism and arbitration famously don't mix. And in 1933, we sort of know what happened in Germany. Professor Nussbaum left Germany and went to live in the USA, and rather sadly wrote a couple of pieces on arbitration, well worth reading, but one of which bemoans the failure of the arbitration movement. He sort of suggests that it was all a bit of an illusion. What had happened was that the ratification of the Geneva Protocol and Convention was pretty sparse. A number of major countries didn't ratify the two conventions, I think we'll call them, which had resulted in them not being very effective. And on top of that, courts had already started to misapply the Geneva Convention by requiring what was known as the double exequatur. The requirement in the Geneva Convention was that the party seeking enforcement had to show that the award was final under the laws of the seat of arbitration and not open to any form of challenge. This had been interpreted to mean that effectively you had to seek enforcement of the award in the place of arbitration before you could go and enforce your award anywhere else. The English courts rejected that view, but everybody else seemed to adopt it. And it's a misreading of the convention. But either way, it had led to a freezing up of the enforcement process. At least that is how it was perceived by many people. Whether that's true is difficult to tell. It's probably more likely that the national courts were simply not well enough equipped to cope. Well, after the Second World War, this is a picture of Peter Sanders, the drafter, as it's always suggested, of Article 5 of the New York Convention, although when he drafted, I think it was going to be Article 4. Nobody was quite sure what to do next, except that the Geneva Protocol and Geneva Convention had not been widely accepted, and something needed to be done. 1953 saw the International Chamber of Commerce drafting a draft convention to be adopted, and this led to the New York Arbitration Conference of 1958 and the resulting convention. It's always said that Peter Sanders had drafted what became Article 5 in the backyard of his parents-in-law's house in upstate New York. Whether that's true, I don't know. Probably is. So it doesn't sound very plausible otherwise. Peter Sanders also produced what you could describe as the second generation of yearbooks. The one you have on your screen is actually from the third generation. But it does trigger a degree of revival of the arbitration movement, if you want to call it that. Although by 1958, Arthur Nussbaum has long been forgotten. Many of the same people gathered together in Geneva in 1961 for the European Convention on International Commercial Arbitration. There were lots of different agendas here, but one of the big ones concerned Eastern Europe. What was described by the West as the Communist bloc and by the East as the Socialist bloc had owned a number of arbitration bodies. So you agreed to arbitrate with the Bucharest Arbitration Court or whatever it was. It was owned by Romania. Having said that, CTAC is owned by the Chinese government. So nothing's really changed in that respect. But one of the big question marks was whether or not the courts would enforce an agreement to arbitrate at one of these state bodies, and it was agreed that they should. And that made life a lot easier. Article 9 of the Geneva Convention said that an award that had been set aside in its place of origin could actually be enforced unless the setting aside had been based on one of the grounds listed in Article 9. This resulted in the UK and Switzerland refusing to ratify the convention. Strange, of course, because Geneva's in Switzerland. The reason for this was that the English had their case stated procedure, they'd had it since 1889, in which there was in effect an appeal on a question of law. And that wasn't one of the Article 9 grounds. And the Swiss had something of a tradition, even by 1961, of setting aside awards on the basis that they failed to meet the administrative law standard of arbitraire or arbitrariness. And that also wasn't a ground under the Geneva Convention. It's one of the great academic questions as to why Cuba and Upper Volta ratified the European Convention. It sort of doesn't quite make sense. Beyond that, well, 1965 saw a failure and a success. The 1965 Strasbourg Uniform Law was a disaster, really. I mean, it's where the idea of trying to uniformitize, or unify, I should say, arbitration law across the world finally hit the road and resulted in only 2 countries ever ratifying the uniform law, Belgium and Austria. Only Belgium ever implemented in any sense, but it remains as the father of the UNCITRAL model law. The correct answer to any assignment on this course is never ICSID, because we don't cover ICSID, but the Washington Convention did develop its own setup for international investment contracts involving a state, and that remains in force. But the first modern arbitration statute is the Swiss Concordat, and that was the work of André Ponchot, who'd been the arbitrator in the Essien Yugoslavia case, in which a Swiss court in the seat of arbitration had managed somehow to refuse to enforce an award while declining also to set it aside. And this caused chaos in the Dutch courts and then in the French courts, who ultimately enforced the award in the 1980s, an award that was issued in 1956. Not impressive at so many levels. But anyway, the Concordat is a strange phenomenon because Swiss cantons can either accept or reject a Concordat, but if they accept it, they have to enact it in full, quite unlike the model law in this respect. But it is the first real effort to have a modern arbitration statute, and as such, it's pretty impressive. I should add, it came into force in 1972, but a number of countries didn't ratify it, or cantons didn't ratify it, until well into the 1980s, notably Zurich and Thurgau, two very late adopters of the Concordat. And then we get the phenomenon of the last and present version of the yearbook, and you've got a picture of what they look like nowadays. All these yearbooks follow the same format. The editor would send out to the country correspondents a string of questions to which they received answers, and were able to print them on the basis that, in Germany the answer to this question is this, and Switzerland it's this. It's not always terribly accurate, but it represents a huge step forward from a comparative law point of view. The French in 1980 overhauled their arbitration legislation. They then tacked on in 1981 a section to cover international arbitration, which wasn't subject to the first part. Now it's slightly different in that there is a domestic section, an international section, and there's also a provision which explains that in the absence of contrary agreement, the following provisions, a number of listed provisions of the domestic bit, apply in international cases. And that does create a slightly higher degree of coherence, although it's a bit more fiddly. The model law comes to fruition in 1985, originally planned for developing countries, not for countries like Germany, but subsequently adopted it. The United Nations initiative, and a lot of the big hitters in the international arbitration world sent their top experts along. And as a result, the model law does actually stand up as a very impressive achievement in many ways. The model law gets a degree of discussion, but in the 1980s amongst developed countries, the countries like Holland basically ignored it in their modernization of their legislation, which originally went back to the 1830s. The Swiss did the same. LDIP stands for Loi fédérale sur le droit international privé. That's the French version. In Germany, it's the IPRA Gesetz, Internationales Privatrecht Gesetz, same meaning. So if you use the initials IPR, or IPR with a small x, you're absolutely on the money. In English, of course, it's the Private International Law Act. Please don't use that abbreviation, PILI. You see it in the literature, but it doesn't relate to one of Switzerland's national languages, and it looks ugly as a result. But it's chapter 12 of an overall overhaul of Swiss private international law. It only applies to international cases. And in fact, you can contract out of it in favor of what is now the Federal Code of Civil Procedure, and was originally the Concordat, of course, if you wish to. The English implemented the 96 Act, came to force in 1997, actually. And that is a complete rewrite of English arbitration law. From top to bottom, in an attempt to be user-friendly, the legislature has effectively gone to enormous lengths. It's a very long piece of legislation, but not a bad effort, really. Most commentators in Europe like it a great deal, with the exception of the retention of the appeal on the question of law in section 69, which can be excluded by the parties' agreement. The Germans adopted the model law in 1998, subject to their own twists, which most people thought was completely unnecessary, because German arbitration law was in fairly good shape anyway. And the Swedes purported to adopt the model law, but actually rewrote their Arbitration Act from 1927 in 1999. And they've done it subsequently too. Still, you get small tweaks to the German statute in 2001. And above all else, the revision of the model law in 2006 to incorporate provisions dealing with interim measures issued by arbitrators. It introduces the idea found actually in the Ulster rules just before the 2006 revision of the emergency arbitrator, which is becoming an interesting modern phenomenon. But there's a great deal of stuff there on the arbitrator's power to issue interim measures and the emergency arbitrator's powers, which you will be studying. There's also a change to the requirements for an agreement in writing. Basically, the old New York Convention requirements of Article 2.2 are softened to the point of non-existence, one option gets rid of formal validity altogether, and the other adopts what is usually known as the English rule, which is that if you orally agree to a written document, that's good enough. You don't have to show documentary evidence of any agreement to arbitrate. The French did a bit of a gutting or cleaning out of their statute in 2011. The provisions are renumbered, which is annoying, but the fundamentals haven't changed. The Belgians did something similar in 2013, and the Dutch did a cleanup in 2014, and the Swedes did a grown-up amendment in 2019. Be very aware, because it's quite easy to find yourself looking at the 1999 version, not the 2019 version, which is the one you actually need. And finally, the Swiss made a number of slightly eccentric amendments to the LDIP, most of which weren't really necessary, but they're part of the story. And that pretty much brings you up to date. And hopefully you'll be able to study the Geneva Protocol and the Convention in more detail using the video I'll do very shortly. But in the meantime, thank you very much.